Are Southern Baptists due for a serious showdown when it comes to church polity? Well, it looks like that may be the case. The Executive Committee has now filed an amicus brief in the case with McRaney versus the North American Mission Board. Now, for several years now, a number of individuals and other leaders across our convention of churches have been calling for the Executive Committee to stand up for the polity, which has been historic among Southern Baptists. And that has not been done. In fact, they've been basically voiceless. We hadn't heard anything at all. And then several weeks back, we had an amicus brief that was filed apparently without the knowledge of the Executive Committee board members, and that raised all kinds of a ruckus. And so now, as of yesterday, this brief was filed on behalf of the Executive Committee representing the Southern Baptist Convention, obviously. And in the process of that, we now have some very interesting things that have taken place. Now, the North American Mission Board has put on documents in the court filings a number of things that have been counter to what Southern Baptists have understood to be our polity over decades and decades now, including the autonomy of a church, the issue of hierarchy. They've used the word hierarchy, being a supporting organization, several of these kinds of things. So all of these things have been of real concern. And so many have been calling out, asking that the Southern Baptist Convention's Executive Committee speak out and clarify polity. Well, they finally have filed an amicus brief. A new law firm, Crane law firm, has now taken hold of this. And at this point, I've not gotten any information, nor have I seen any information to say how much of the Executive Committee board there are familiar with this, that this was approved by the board or whatever. But there's some real concerns I have. And what I'm flashing around here, I know that's a little distracting, but this is the actual document. This is the amicus brief. I'll put a link to this down into the video description when I get through here. But anyway, you can download this and look at it for yourself. But there are some real concerning things. One, it sounds to begin with like the Executive Committee is reinforcing exactly what McRaney has been claiming and what he has been saying as far as the autonomy of the local church, the autonomy of our state conventions and associations, that all of our entities are autonomous. And it begins reading that way and seeming like they're going to line up with that. But then when you start looking at the table of authorities here, you'll notice that there are a number of the authorities that are quoted throughout this that relate to denominational groups that are unlike Southern Baptists. Of course, Southern Baptists are very unique, but here's one from a Lutheran church, Evangelical Lutheran, a diocese, Cathedral of the Russian Orthodox, Salvation Army is one of them that's listed, the Watchtower Bible and Tract Society, Orthodox Diocese, a number of those. They do come back and list a couple of Southern Baptist documents as a part of their additional authorities. One is James Sullivan's book on Baptist polity as I see it, from the 1998 edition of that, and there's a couple of references there that are used. And then the Encyclopedia of Southern Baptists. Most of you have probably never seen that one, but it was published by Broadman Press back in 1958. And our polity basically has been the same for many, many, many years. One of the severe or serious claims that I've spotted in this, and I've been trying to digest all of this since I saw it come out just a couple of hours ago. It was filed yesterday. But one of the things that is of real concern is that the way they're presenting this is that Southern Baptists are very similar to just basically any other organization or group that's a denomination that has kind of a hierarchy. Now, they state very clearly, this is page 2 of the amicus brief they've just filed, says the SBC is not a hierarchical church. Using the word church, the convention shall consist of messengers who are members of Baptist churches in cooperation with the convention. Most of us would agree with that. That is in conflict with what they filed before the Supreme Court and the U.S. Fifth Circuit Court in some of their court documents at that point as well. The autonomy of churches, it says on page 3 here, is a matter of faith and doctrine, and the amicus files this brief to communicate clearly that to the court, the polity of Southern Baptists and to protect the right of Southern Baptist and all its religious bodies to decide for themselves, free from interference, state interference, matters of church government, as well as those of faith and doctrine. Now, most of us would agree with that and not have a problem with that, but it begins to kind of move forward and kind of degenerate. Now, I've not seen anything from Baptist Press on this, even though this came out and was submitted to the court on yesterday. Baptist Press has not. Baptist News Global did write an article. Mark Wingfield has written an article and make some observations. In great part, the first part of his article just recounts exactly what's taken place and then does a highlight of some of the things that I've read already in that. So I'm going to go over to his article. I'll link this also in the comments when I get, not in the comments, in the video description when I get through here, so you can look at that and see that as well at that time. But let me just give you a couple of things that it says. The executive committee should have an interest in this without any question, for the primary reason that this is determining what our polity has been, and our polity has been this way for a long time. One of the conflicts that I started to mention a minute ago, one of the conflicts is that the assumption is based on what was put into place through strategic partnership agreements, that kind of thing. The assumption is that changed Baptist polity historically. And so that was a contractual agreement between the Baptist entities. In this case, it'd be the North American Mission Board and the Baptist Convention of Maryland, Delaware. But let's come back to that here in just a second. The Executive Committee interest is mentioned here. The brief also positions the Executive Committee as knowledgeable about the so-called ecclesiastical abstention doctrine it claims is key in the McRaney case. The doctrine says secular courts may not intervene in the internal religious decisions of churches and church-related groups. And none of us would have a problem saying, yeah, that's exactly right. The problem is, and the issue comes in, where this document continues to reaffirm in a lot of ways what's already been said, that we're just like one big organization. And they propose that the strategic partnership agreements, which are agreed upon and generally negotiated between the state convention and the North American Mission Board, they come up with a commonality of what they're going to share ministry in. And in the past, this has all changed dramatically since the Great Commission resurgence took place and Kevin Ezell took over there at the North American Mission Board. But initially, these kind of agreements were negotiated between the state convention and their leadership, and they talked about common goals and common paths that they wanted to work together in mission and evangelism work in that given state. And then there was a partnership discussion about how much money could NAMB give back from cooperative program dollars back to that state convention to be able to fund those kinds of things. So that was all part of this strategic partnership agreement. Well, their contention here is all of that has been changed, and that is in conflict with our existing polity. In fact, the direct quote is, it changed the relationship from that which existed under Southern Baptist polity. I don't see that. I was an executive director in Michigan. I was a part of negotiating those agreements. And prior to Kevin Ezell coming, I was in the state for a decade when those agreements were worked on with our state convention. Of course, I was associational missionary at that time. But it was all about agreeing, about cooperating. It was a matter of saying, look, we're just going to put down on paper the things we agree to, and our convention and all of our churches contribute to the cooperative program, and that's sent forward to the executive committee to be divided up appropriately. And then North American Mission Board has this strategic agreement that they decide we're going to give back to the state this percentage of money, this amount of money, and it's going to be agreed upon to be designated between these kinds of ministries at that point. To me, that is just simply a written way of advancing the very polity that we talk about. We're agreeing on paper what we're going to work through and how we're going to fund that cooperatively. The argument here is This is a contractual agreement that says we're all part of one religious organization. Therefore, we all can have influence in those who are hired or fired, those who can, mandate whatever we want to mandate, because we have an agreement and we have an influence in the area of that state convention. Now, that's not the way it's been looked at historically, for certain. In fact, let me give you a couple of other things here. One here, the McRaney case, because he claims one SBC entity, meaning the North American Mission Board, pressured another autonomous body to fire him as executive director because he opposed a changing of that partnership agreement between the regional convention and NAMB. McRaney claims that NAMB and Ezell defamed him and others by urging them not to hire McRaney for considering work and speaking engagements. That was beyond the strategic partnership agreement. Some of you already know they did the same thing to me. The same thing has been done to multiple other individuals. Some of those, their testimony you may have already heard, some of them not, but it has happened multiple times over and over. So the basic content of this new brief has several things that are of concern. And if it comes out on the bottom side, the bottom line, that the executive committee is not actually reinforcing our historic Baptist polity, then this is a serious issue that we need to be concerned about. Even though they state, as we always have agreed, that this is not a hierarchical organization, they come back now and they talk about how this cooperative agreement or strategic partnership agreement created some additional issues and a contractual agreement saying we're all a part of the same. And that's not exactly the way it's viewed. In fact, I don't know any of the executive directors that I worked with, nor any that are probably in that position now that would see it that way, except those maybe that have an extremely high loyalty to the North American Mission Board or personal friends of Ezell or something of that sort. And that's a sad thing. Now, let me state one other thing that's mentioned here. The strategic partnership agreement, the way they've said it is that it's created a legal, operational, and financial entanglement. And they've used the word entanglement to be able to give support to the very fact that we're all part of one. Therefore, the ecclesiastical doctrine that's a part of the First Amendment of separation of church and state means that for them to make any kind of ruling, that the court has to evaluate the doctrine and all of the other interworkings of the Southern Baptist Convention, of the North American Mission Board, and of the Baptist Convention of Maryland, Delaware. And that's not the case. They're saying that they should have a right, they should have the privilege of helping to determine who is employed or not employed. We know that North American Mission Board has actually helped to pay for some of the executive directors' positions as they have given influence, we'll call it influence, but they've given influence in that particular state convention to reinforce their position. I guess I could say, trying to be nice. I'm trying to watch my words. But anyway, because McRaney is a Baptist, the question then turns on where is the line, where should the line be drawn between the doctrinal decisions and the hierarchical decisions within the convention. I want to go back to the article here by Mark Wingfield, and I want to read this short section. This is a really strong illustration that he gives as the way he unpacks this to try to help understand the difference between the hierarchical and the way they are trying to present these strategic partnership agreements and what they have argued. Okay, so let me just give this to you. The executive director of the State Baptist Convention carries a grudge. Now, remember, this is just an example. This is a what if this moves forward as NAMB has presented it, and now the executive committee is reinforcing it. Okay, so remember, it's just an example. Okay, Baptist Convention carries a grudge against a pastor of a local church and wants to get that pastor fired. The state convention official tells church leaders a lie that implicates the pastor in some kind of a scandal. The church, acting on false information, then fires the pastor. Your blood boiling yet? According to the logic of NAMB and the executive committee, that pastor has no legal standing to sue the executive director of the state convention for defamation. This is not about the pastor suing the church for wrongful termination, a case not likely to see the light of day in any jurisdiction, but about the pastor suing an outside party for defamatory interference. To continue the example, what if that state executive director also called around to other pastorless churches in the state and warned them not to hire the recently fired pastor, or else they would fall out of favor with him and the help that he had to offer? Again, NAMB and the executive committee claim the fired pastor should have no legal recourse for that kind of outside interference because the whole Baptist world, while not connected, is subject to the ecclesiastical abstention doctrine. Now, all I've got to say is that's absurd. That's just absurd. It's crazy and should not be carried on at all without any doubt. It's just kind of crazy. Now, let me pause for just a second. We have a comment here real quickly, and let's just interject that. Watching, I'm a pastor of an SBC church in Kilmore, Texas. This is an important issue. If this was to stand, it will bring liability to every church in the SBC. And he's exactly right. In fact, that's the next point I wanted to make, that what we've been arguing, many of us, is that if NAMB gets its way, and apparently the executive committee is reinforcing that if they get their way, then what ends up happening is there's a connectionality. Now, if we look at all of the cases, I saw today, I think SBC litigation is the Twitter handle, but the SBC litigation Twitter, well, it's not Twitter anymore, it's X. But anyway, they listed all of the court cases right now that they're following and where litigation is taking place. And I didn't actually count. It was three different tweets or threads in that. And it looked like there's probably 15, 16, 18, maybe even 20 cases that were listed. Now, understand, it's not unusual for the SBC to get sued. Some attorney somewhere gets in the middle of a lawsuit with the church. Somebody slips and falls going down the front stairs of a church, and they think, hey, we'll sue the big guys. We can get money. So this isn't unusual for somebody to sue. But these cases are, most of them that I saw, were very, very significant. Cases of either abuse, cases of misrepresentation, abuse of power, number of different things that could have been in there. And I'm not an attorney and I don't follow all those that closely. But when you look at those, one of the things that has always stood for Southern Baptists is the reality that we're all autonomous. And so I don't have any hierarchical power over you in your congregation if I'm a state executive director in a state convention, nor if I'm an associational leader. I don't have any authority over you, and nor does any entity, Lifeway or NAMB or any of the seminaries, nobody. They don't have authority over the other. So what happens in the SBC is when somebody sues the SBC, in years past, the SBC attorneys, they will simply respond back to that court and say, look, all of our congregations are autonomous. Our organization is autonomous, and explain that polity that's been the historic polity of Southern Baptist. And it goes away because we are not responsible for the others. We operate independently, autonomously. We make our own decisions. We're self-decision-making organizations at that point. This binds us together. So now we have to look at the potential of ascending and descending liability, which means if somebody's sued in a particular court, it might be just in your associational area. They can say, hey, you're all part of that association, and we're going to link you all together. So now we're going to sue every church that is a member of that association because there is a connectivity now. Same thing in the state convention or the SBC as a whole. And the reality is that'll never stand. There's no way that that can happen. And to be honest, I think what will happen is this is going to be a showdown in polity without any doubt, because this has got to be worked out and it's got to be made clear. And I think there will be a quick exodus, let's just call it that, a quick exodus of many, many more churches that look and say, I am not going to be connected to all of these churches and organizations if that means my church is now going to be financially liable. I'm going to be legally liable, et cetera, because of the connectivity of all of this. It's just, it's absurd to think that way. And I wouldn't lead my church to continue in that way at all, even though I have close friends and brothers that are fellow ministers of Southern Baptist churches, and we love fellowshipping together. We love getting together. We love ministering together. All of those things are great. Those are wonderful. But you know what? Many of those are going to say, I'm sorry, I'm done with the SBC. I'm pulling out. I am no longer going to stay. So this showdown in polity is going to be a drawing line. It's going to be a line in the sand, as they say, and just determine, hey, how many more churches are we going to lose? There's a lot of churches that have already left over the last few years and the controversy going on. There are additional churches that have left because of the way the abuse situations have been handled. And there's all kinds of other situations that are continuing to rise to the surface. So I want to encourage you to, one, stay aware of what's going on, be alert, and keep in mind those things that are happening at this time. And then as you do, don't forget that this all reflects back on you as an individual, as a church, the SBC. And I'm SBC from the womb and before, graduated from 4 different cooperative program supported institutions. I mean, I'm deep Southern Baptist, but there's going to come a time. It's just hard to imagine that we're going to have churches that want to continue to stay in the process of where we are right now. It's going to be a SBC Polity Showdown, no doubt. I hope that you'll seriously consider this and keep track with this. We'll try to keep in touch of everything going on in the future and try to keep you posted as well.